Please be seated. Good morning. Welcome to the First District Court of Appeal. We have two cases on our docket this morning, and we'll take them in the order of the schedule. Our first case is Churchill v. DBI Services et al., 21-3199. Counsel, are you ready to proceed? Proceed when ready.
Thank you, Your Honors. May it please the court. Counselor. Good morning. I'm Mike Weiner from Tampa, Florida, and I have the pleasure of representing the appellant in this case, Ms. Churchill, and I would like to reserve 5 minutes for rebuttal, please.
5 minutes, so noted.
Thank you. Your Honors, Ms. Churchill worked as a restroom attendant for DBI Services, and on November 1st, 2020, she was called in on a day that coincidentally was her day off, and came to work, and her responsibility was to clean restrooms. And as part of that, they had a protocol there with the employer in which the restroom attendants would gather in the area and mix certain chemicals. She was not exactly aware of what the chemicals were that were already in the bucket the day that she got there because they had been left there by a previous employee. And as she started mixing bleach and hand soap along with the other chemicals that were already in the bucket, a sudden explosion, as she described it, that occurred that was similar to what you would envision as a high school volcano science project. And she was engulfed by all these toxic, multicolored fumes and vapors that she breathed in, and immediately caused a significant allergic reaction to her eyes, a coughing spell. Make no mistake about it, Your Honor, this event was sudden, it was unexpected, and it immediately resulted in injury to her.
Well, you just said toxic substance, which goes to your fourth issue. First of all, you didn't mention the exposure issue in the reply brief, to my knowledge. Are you abandoning that issue?
No, sir, we're not, and it's a good question. We just felt that it had been adequately addressed in the initial brief, and so we stand on the arguments made in the initial brief.
Okay, so you said toxic substance, so you acknowledge then that this, soup of chemicals was a toxic substance?
Well, obviously, because of not only the medical diagnoses that were made, but because we know at least some of what the substances were. One of it was bleach, industrial bleach. We know bleach is toxic. That's a matter of common sense. Also, we knew that at least one of the other materials, whether it was this Honey Bowl toilet cleaner or something else, was an industrial cleaner. So, those are, substances which everyone would understand to be harmful to individuals.
So why was it error then for the JCC to apply the exposure requirements, the heightened requirements for exposure to the injury here?
Because of what the nature of the accident was. This was a sudden and an unexpected event where she was engulfed, in what she described again as this sort of scientific high school volcano type of experiment. And there was immediate reaction that she had. Typically in exposure cases, we think of something that's a little more gradual and insidious, right?
Counsel, I agree that is typically what we see, but what is it about the sentence in 440.02 sub 1 that excludes a single exposure?
Well, it doesn't, but by the same token, this accident clearly also meets the legislative definition of an accident, right?
Well,
so
no,
it was a sudden
because
and unexpected event.
The way I read the exposure sentence is that, excuse me, an exposure to toxic substance is not an injury by accident unless it meets the heightened standard. So doesn't that exclude the first sentence that defines accident?
Not necessarily, because again, this was not just an exposure. We more liken the situation of what happened to Ms. Churchill as being as if she was burned, right, by a fire, or if she was burned even by chemicals on her skin. No one would call that an exposure. That would be an actual, physical touching. And because she was physically touched by, the reaction to the chemicals that she dealt with, our position is that categorizes this as an accident, not an exposure.
Don't most exposures involve some sort of touching with some sort of a substance?
Not always. A lot of times, especially when what you see most frequently, the case law that this court has interpreted has been with regard to mold claims. And these are, invisible things that you never even know that you're coming in contact with that happen quietly and insidiously. Excuse me, I'm sorry?
I'm sorry, you are coming in contact with something.
You are,
Through your
but you
nose,
don't
through your
really
mouth.
know it, and there's no real physical contact that you appreciate at the time. The difference here, and I understand that it's a subtle one, but is that she actually came in physical contact with these chemicals. This was something, by all accounts, and the testimony is unrefuted on this point, that this was an actual physical touching of her, just as if she had been physically touched by a caustic acid or been physically touched by a hot flame. And that's what distinguishes this as an actual accident versus an exposure.
The sentence Judge Winiker is referring to has a including but not limited to fungus or mold clause. Does that have any bearing on our interpretation of what exposure to toxic substance means?
Well, I mean, obviously the legislature gave two examples of what it intended. I think by virtue of the examples that they provided, what the legislature contemplated was more of these type of, mold, fungus cases and not necessarily chemical cases. If the legislature had intended also to say, we mean, exposure to actual, man-made solvents and chemicals, that would have been listed in section 440.02, but that wasn't listed in there. And I think we go back to, and I know this wasn't mentioned in the briefs, but I didn't expect this line of questioning. The canon of statutory construction is the inclusion of one thing implies the exclusion of another. And so if we're going to apply that canon of statutory construction to this, we can see that the legislature has only sought to include molds and fungus, those being sort of living toxic organisms as opposed to man-made ones. And I think that provides you with an indication of legislative intent that these exposure to these man-made chemicals was not something that was intended to be included in section 440.02.
Do you think, does the sentence in 440.02 sub 1, does it apply to any single exposure to some type of a toxic substance?
Well, clearly you could have one single exposure to mold, and that would be clearly within the purview of section 440.02. So I don't think, to be fair and answer your question, you're right. I don't think that the statute necessarily differentiates between one single exposure versus a cumulative set of exposures, which is what we typically see in these types of cases.
Can I jump you to your second issue before we burn through all your time? When was the commencement of payment to require the EC to send the 120-day notice?
Yeah, so the carrier had, within the first 14 days, had begun the initial payment of compensation benefits. So the statute obviously says upon payment of benefits, and so we know that was within the first 14 days, according to the record evidence that we have, the carrier began paying the claimant's indemnity benefits. And it leads to a very critical point, Judge, that upon means something very important legislatively. There are clear edicts that are contained in this statute that the carrier has to abide by in order to properly deny the case. Otherwise, under section 440.192 subparagraph 8, they've waived the right to deny compensability. That is a matter of very clear legislative fiat, I would suggest to you. And what the carrier has to do is they have to, upon payment of benefits, and upon, which would have been within the first 10 days, in this case should mean as soon as reasonably practical, right? As soon as the carrier started paying those benefits, they had an obligation under the plain legislative fiat to tell the claimant either we're going to pay your case, we're going to deny your case, or we're going to pay and investigate. And they didn't do that. They just agreed to pay it. As a matter of fact, the adjuster's testimony later on is that, yeah, we accepted the case as compensable, and that continued to be the case. And the carrier really had no new information, according to the adjuster's testimony, that led to its denial, other than a fact, apparently, somebody changed their mind and said, we don't think it's compensable anymore because you can't meet these heightened requirements under the exposure statute.
Is there a way that we can draw a line consistent with the statute on what, when it's too late under the statutory phrase, term commencement?
Yeah, well,
Does that make sense?
Upon means something, right? If you were to instruct me, Your Honor, that upon getting back to Tampa, you are to file a notice of supplemental authority, you wouldn't expect me to do it 67 days later, like the carrier did here when they filed their 120-day letter, right? Upon means doing it as soon as reasonably practical under the circumstances. And so that's how I would answer that question. It doesn't mean you have to do it immediately. It's not a fire that needs to be put out that very second, but it needs to be done in a reasonable amount of time and as soon as reasonably practical. And that is not waiting 67 days while this poor woman had no idea that her case was being subject to investigation or later denial. Because what happens in that situation, if carriers don't alert claimants as to what their rights are, which is exactly what the legislature requires that they do, then claimants sleep on their rights. They don't conduct the investigation necessary. Ms. Churchill doesn't hire a lawyer. She doesn't send somebody to go in there and find out what the chemicals were. She doesn't tell her lawyer to, go in there and do a motion for view of the premises to be able to go in and look and see what are the chemicals that are involved here, so that they could then provide them to the experts and have the experts say, yeah, here we go, I've got the exact chemicals that she was exposed to, and now we can testify within a reasonable degree of medical certainty what exactly these chemicals were and what the levels were she was exposed to. She's been denied that because the carrier did not send that letter upon commencement of payment of benefits.
Am I correct that you only need to prevail on issue 2 or issue 4 to have this be compensable? You don't need to win both. If we reverse on either one of those 2 issues, it goes back to the JCC as compensable, and then, whatever benefits, are received from that is a subsequent determination.
Correct, Your Honor. You bring up a very important point, and I'll eat up a little of my rebuttal time because I want to answer it. If you remand on issue 2 or 4, right, on either the fact that this was an accident or the fact that the carrier waived its right to deny compensability of this accident by not perfecting its rights or its responsibilities under the 120-day rule, the claimant has suffered a compensable accident. The carrier still has outs, right? The carrier still, under section 440.1928, still could come back and say, look, there are material facts relevant to the issue of compensability that we could not have discovered within the 120-day period. They would still have that out. And the claimant still always has the burden of major contributing cause, right? So under the Checkers case and the Wooling case that we've cited in our briefs, right, the carrier still has outs in the sense of, they can contest medical necessity of any particular medical benefit. They can still contest whether the work injury remains the major contributing cause of any new treatment that's recommended, and they have all of their indemnity benefits. All the carrier has lost by failing to do what they were supposed to do under the statute is the right to say this accident was not compensable.
Thank you, counsel.
Okay, I'll save the rest of my time for rebuttal. Thank you.
Thank you. They were having technical difficulties with that yesterday, so I'm glad to see that you're able to make that work. You got to start talking and then the clock will start.
I'm sorry?
You were looking at the clock like you're waiting for it to
Yes,
start.
I'm waiting for a light or something to say, go.
That was me looking at you with a nod, so whenever you're ready.
Okay. Your Honor, I am Jane McGill. I represent the employer carrier in this case. Your Honors, opposing counsel. With regards to the argument that this case does not involve a toxic exposure subject to the clear and convincing evidence standard and creates a presumption, I would like to point out that it is a toxic exposure, and it's a one-time exposure, which this court has addressed in other cases, saying a one-time exposure is all you need to a toxic ingredient, is all you need for it to be a toxic exposure. So the issue here is what's toxic? What is a toxic substance? And there can be, toxicity is a substance depending on 3 factors. It's a chemical structure, the extent to which the substance is absorbed by the body, and the body's ability to detoxify the substance. Interestingly, there are some funguses and some molds that are not considered toxics. They are considered pathogenic or allergic. Toxic is a chemical in a poisonous chemical which only certain fungus and molds create and can cause harm to a person's body.
Well, isn't it undisputed that we were dealing with bleach and hydrochloric acid, both of which would pretty commonly be thought of as toxic substances?
Chlorine, bleach is definitely a toxic substance
Okay, so how,
at a certain level.
sure.
There's a safe level for bleach and chlorine, and then past that bleach, past that safe level, it can be toxic.
And the fact that one of the treating doctors said that she suffered an abrupt injury to her lungs by the exposure to this substance, why is that not enough for it to be an accident under the first sentence in 440.021?
Because the legislature has found that any toxic exposure, even one, takes it outside the realm of an accident, a sudden and unexpected accident as defined in 440.02. The issue, I'm assuming for the legislature, was that with toxic substances, it is more difficult it's so widespread. The toxic substances could be found at home, it could be found at the workplace, it can be found while working in a mall. So it is harder for an employer carrier to determine where was the injured worker when they were exposed to this toxic substance.
But that's not really an issue here, though. I mean, she was transported by ambulance to the hospital the same day and was then hospitalized for 5 days thereafter with no pre-existing conditions. So, I mean, it's pretty clear that her exposure to whatever this cloud was caused the injury, right?
That exposure, but the statute says they then have to prove what was the nature of the toxic exposure.
And it was bleach and acid, isn't that enough?
And the initial emergency room physician said it was chlorine. The burden then became for the claimant to prove the amount of chlorine that she was, or
I mean,
bleach.
she has to say that this is like it's been a long time since I've had chemistry, but a 5-mole solution of, whatever chlorine, or can't she just say it's chlorine? I breathed in chlorine. I was fine before. I breathed in chlorine. I was hospitalized for 5 days. Why isn't that enough?
That's not an accident because the plain meaning of the statute says it was a toxic exposure, so it's not an accident.
Is your argument the same if she were to have burned her hands instead of burned her lungs with the substance?
I would say, given the employer carrier followed the rules and they provided treatment, they were not uncertain at the time. They became uncertain later whether the toxic exposures continued to be the need for medically necessary treatment. So the defense was that you have to prove, for the defense, it was more not at the time of the exposure, but now and continuing, you have to prove that the exposure to chlorine or bleach 8 weeks ago is still causing these symptoms. And the defense was saying that the claimant did not sustain her burden of proof. She didn't prove that she had been exposed to so much bleach, so much chlorine, that 8 weeks later, it was still causing the major contributing cause of treatment.
Let me get back to, I'm going to follow up on Judge Bilbrey's last question and ask you to, excuse me, respond to Mr. Weiner's contention that, correct, I apologize if I'm not stating this exactly the way you said it, but that a physical touching is not the same thing as an exposure. I think that's pretty much what Judge Bilbrey was asking about, that if she had injured her hands by maybe sticking them in the solution rather than breathing it in, does exposure not require a physical touching? And if so, is that what happened here?
I think a touching is an exposure because it all depends on how much toxic chemicals did the touching, was it sufficient to cause the symptoms.
So your
You know,
answer
and-
to my earlier question was if she burned her hands in the bleach, that's an exposure case, and she has to prove by clear and convincing evidence what happened. Is that correct?
To me, any doctor, you need medical evidence. All you need is for a doctor to say, yes, that amount of bleach that she touched would cause the burns on her hand. It's clear and convincing. I don't think you would find any doctor who would not say, I am certain within a reasonable degree of medical certainty that that amount of bleach that she touched, a quarter of a cup, extrapolated out, caused the burns on her hands.
I mean, isn't that what we have
The
here?
litigation in this case, all of the attorneys and all of the doctors were focusing on the combination of chemicals. What were the chemicals in that whole 16-ounce bottle of cleaner? And so they kind of got distracted from just focusing on the chlorine and how much. They knew that there was a quarter of a cup that was added to the solution, and in my research, is very clear that they know exactly how much chlorine exposure is safe. Anything above it
I mean,
is not
clearly
safe.
this wasn't a safe exposure here. This wasn't like somebody that had breathed, some mushroom spores like one of our cases, and then maybe suffered an injury months later. This is pretty much instantaneous. She breathes it, she feels bad, she calls her boss, they call an ambulance, she goes to the hospital, and she's hospitalized for 5 days.
Yes, and so it was.
So what more does she have to do to prove that the inhalation of this substance was the MCC of her injury?
She would have to have a medical expert, her IME physician possibly, testify that we know that a quarter of cup of chlorine went into that 16-ounce bottle. We know that when it vaporizes, approximately the amounts of chlorine that are considered safe or not safe is measured in ppms. I have no idea what ppms mean, but a medical expert would know.
I think it's
And-
part per million, but.
Oh,
but-
okay.
But isn't it clear here, though, given,
So a medical expert would be very easy, I would imagine, and I say that as an attorney going to physicians and saying, recently with the Daubert, I had to explain to doctors over and over again, your training and experience are not enough. You need studies to back up your opinions.
And
With
I'm-
the clear and convincing toxic
I'm following you
standard.
if 3 months after she had breathed in some bleach, she came in and was saying, I was exposed to bleach or, silicon, asbestos, mold, fungus, whatever. I was exposed to a toxic substance X days, months, years ago. That's caused my injury. Whereas here, it was the sudden and unexpected nature of the injury that seems to make it potentially an accident instead of an exposure.
Well, the legislature does not leave open that option. In the plain language of the statute, they do not leave open that option of saying that, well, if you have a sudden an exposure and it causes immediate symptoms, then that's an accident. But if you have a toxic exposure and it doesn't manifest, the toxicity of the substance doesn't manifest until months later, and it would just create more confusion with litigation if you were to say, okay, there's two kinds of toxic exposures. One is an accident pursuant to the definition of 440.02, and another one is a toxic exposure that manifests months later, and then the claimant has a presumption, the employer carrier has a presumption, and the claimant has to prove with clear and convincing evidence. Let's keep it simple, make it fun, and say any toxic exposure needs to be proven with clear and convincing evidence
Well,
by the claimant, which is really no difference because
Can I ask you,
every
can I ask you,
accident.
counsel, 44009, though, talks about occupational, where was it? Occupational injury, where it was occupational disease or repetitive exposure requiring clear and convincing evidence. Clearly, this wasn't a repetitive exposure case, right?
Clearly.
So it's occupational disease, again, seems to me to be, asbestosis, silicosis, something that you get from a repetitive exposure as opposed to a one-time thing. Are you contending that this was an occupational disease that she suffered?
Again, the plain meaning of the statute, the legislature intended to separate out toxic exposures from occupational diseases.
Let me shift gears on you and ask you about the 120-day notice issue. Can you tell us how we should interpret the upon commencement of payment language?
Yes, Your Honor. The claimant's argument that the notification letter is mandatory has already been addressed by the first DCA in 2006 in Checkers v. Whitehoff. In that case, it was actually the employer carrier who argued that we didn't send out a notification letter, therefore we're not subject to the 120-day rule. We can deny anytime we want. And there's some merit to that argument because 44020 subsection 4 is contradictory. The first three sentences make the 120-day rule appear to be an option. If you're uncertain of your obligation to pay, then you can have 120 days to pay and investigate, but send out a letter notifying the claimant. It's the fourth sentence that the court in Checkers decided that they would enforce because the fourth sentence, which says the 120 days starts at the first date of treatment, makes it mandatory. So the court in Checkers said the notification letter is immaterial, and it implied that uncertainty is immaterial to the start of the 120-day rule. They interpreted the statute in a way that provided the employer carrier with 120 days, mandatory, whether or not they're uncertain or not. Soon as they provide treatment, they have 120 days to deny compensability of the injury, and that's inconsistent. If you are to accept the plain meaning of the statute, you then have to decide whether the statute, I would argue that you have to decide whether the 120-day rule is optional, providing the employer carrier with the option of investigating, which furthers the intent of the workers' compensation law to provide medical benefits and compensation benefits immediately when an injured worker is most in need during the acute phase of an injury, most in need of medical treatment and most in need of finances when they can't work. So it gives them the option. But if you're going to, the plain meaning, if you were to accept the plain meaning of, you can't accept the plain meaning of both the first three sentences and the fourth sentence. It's either mandatory, it's either optional. The employer can either avoid paying attorney's fees by utilizing the 120-day rule, or they can just deny from the get-go, just deny, make the claimant prove with medical evidence that there was an injury, there was a compensable accident, medically necessary treatment is needed, he or she is really disabled, and then you have the specter of possibly paying for attorney's fees. And that's the purpose of 44020, in my opinion, 44020 subsection 4, is to make sure and to motivate employer carriers to provide quickly and efficiently medically treatment and compensation benefits and give them some time to decide whether really this is a compensable accident and compensable injury.
And Counsel, you're over your time, but can I ask you just briefly on the issue of the deposition of the corporate representative? It seems pretty clear that 44030 plus the comp rule of procedure allows for depositions like in a civil case, and Civil Rule 1.310 provides for corporate representative depositions, which they tried to take. So at the very least, don't we need to send this back to allow them to take a corporate representative deposition?
You can take, any attorney can take a corporate representative's deposition as long as it's reasonably calculated to lead to admissible evidence. The JCC in this case knew that, and it's in the record, that opposing counsel, the claimant's attorney, had the employer representatives' depositions, numerous employer representatives' depositions taken, scheduled, and corporate representatives, would they really know what's in bleach? It was not. And the judge did not immediately deny the taking of corporate representatives' depositions. He said, you take the depositions of all the employer reps that you have scheduled now. We'll revisit this. If you need to take a corporate representative, you still need to take a corporate representative's deposition because you feel they will be able to give you the information. It's reasonably calculated to lead to admissible evidence. We'll revisit it at that time.
Aren't they obligated, the EC obligated to put forth a corporate representative under 1.310? They've got to make somebody available as a corporate representative, and the JCC erred when saying that that rule didn't apply.
If it's reasonably calculated to lead to admissible evidence, yes. I have attorneys who want to take the CEO's deposition of Barnes & Noble up in New York.
Well, sure, I mean, that's the apex doctrine that we put in place and the Supreme Court adopted, so that's what I wasn't asking about. But I think we've burned through plenty of your time unless further questions. Thank you, we appreciate it.
Thank you, Your Honors.
And we'll give the Claimants Council an additional 3 minutes since we've asked a number of questions.
Thank you, Your Honors. May it please the Court. I'd like to begin where you left off, Judge Bilbrey, and I think it's an important question. No question, the judge of compensation claims erred on the corporate representative deposition. He not only denied the claimant's motion to compel, he granted the employer carrier's motion for protective order. The claimant was 100% foreclosed from the ability to take the deposition of a corporate representative. The import of that is those statements and that testimony of that designated corporate representative binds the corporation. There's no way the judge of compensation claims could have known what was reasonably calculated to lead to admissible evidence from a witness who he had no idea what the witness would say or what the witness would reveal. That involves complete divinity of the unknown, a power which no judge or no human has. Because we know that it's error, we also know that under the Special versus Boca West case, that the employer carrier, as the beneficiary of that error, had the burden to prove in its briefs that there was no reasonable manner in which that error could have contributed to the verdict. They didn't even address that point. And so I would humbly submit to Your Honors, that is fertile ground for reversal on that point alone. It is absolutely clear the judge made error. And if nothing else, I think judges of compensation claims need to understand that these rules do apply, right? The corporate representative rules apply. Section 440.30 says it does. The 60Q rules say it does. And your Latour decision from about 9 years ago also says that it does. So we have reversible error right there. Let's go to the other point that was made, and questions were asked about this, about the uncertainty. We heard counsel for the employer carrier say that the employer became uncertainty. I would humbly suggest to you there's absolutely no record evidence of anything new that developed that led to the carrier becoming uncertain. Instead, as a matter of fact, the adjuster's testimony confirmed that. If you go back, and we've cited it both in the initial and the reply brief, The adjuster's testimony confirmed that when they denied the case, they had no new evidence. Now, when they denied the case, what did they say? They say, you can't meet this onerous exposure burden, something that presumably the employer carrier should have known since day one, right? If their position was all along that this was an exposure, that was not something that just randomly came about. They knew from the very beginning what the nature of the accident was, and we, again, maintained steadfast this was an accident, not an exposure, but the carrier knew from the very beginning what this was.
What does the Checkers restaurant case or en banc case from 15-plus years ago now mean? How does that impact this?
Yeah, I simply do not read Checkers the same way that counsel for the appellees read Checkers. I read Checkers to stand for the proposition that if the carrier, waives the right to deny compensability, that they still have the right to come back later on and contest issues of medical necessity, major contributing cause. That's what Checkers stands for. Checkers does not deal with the mandatory nature of the 120-day letter. I think Bynum sets the stage for the arguments that we've made here, and we've argued the Bynum case in our brief. The appellees have too. And the Bynum case, which has been relied on numerous times by this court, says there are three things that you need to do when you're the carrier and you start commencement of payment of benefits. You either accept the case, you deny the case, or you send a 120-day letter. Those are your three options. And those three options, let's put some context around this here, because this is supposed to be a system that is designed to operate quickly and efficiently. We have trials that have to be had within 210 days, obviously, and the complete legislative intent behind Chapter 440 is that we have an efficient system that provides benefits to injured workers efficiently. So we need carriers to make quick decisions about what they're going to do. And the unambiguous, plain language of the statute is that if you're going to make the decision, if you're going to accept it, then you accept it, that's fine. Even if you accept the case, you can still, like I mentioned earlier, you have your outs later on that you can say under 440.192, there were facts about the compensability of the case that we could not have reasonably have discovered within 120 days. And number two, carriers still have an out to say the treatment's not medically necessary, it's still not causally related as it pertains to individual treatment. But if you accept the case, then the case has been accepted as compensable, and that's what happened here. And if you're uncertain about your obligations, which I would submit to you probably was the case here, the carrier, or at least they tried to play Monday morning quarterback and say that we were uncertain, then you have to send a 120-day letter. And the reason is...
Am I understanding you correctly, your previous answer, that the upon commencement is a fluid timeline?
No. It is to be done as soon as the carrier makes its first payment of benefits. That is when the carrier has to send the 120-day letter. It is not something to be sort of, invoked later on down the line. And then I would submit to you the reasoning is so that you can avoid the exact problems that happen in this case, right? If the carrier waits 67 days before sending its investigation letter to the claimant, then what ability does the claimant have to go back into that janitor's closet and put all these chemicals together and say, here's what it was that I was exposed to?
So does the letter need to issue literally the same day or the same moment as the check?
I'll go back and I'll say as soon as reasonably practical thereafter.
And so that's my point. So there's some fluid.
Some fluidity, yeah. I mean, it doesn't, I'm not trying to say that it would be a hard line, it has to be done the same day, but I think, reasonable always contextual, right? But, reasonable under the circumstances, waiting 67 days is not reasonable by anyone's measure, right? That is not congruent with a legislative edict that tells you you must do this upon commencement, right? Because upon means something, and it means the legislature wants you to do this, I would say, as close to immediately as possible. And, based on the number of errors that we've identified, we feel, and including the first point, which we never even got to, but we're not certainly abandoning that, the judge should not have dismissed the attorney's fee claim with prejudice, but also the judge's error in terms of not allowing a corporate representative deposition, the judge's error in categorizing this as an exposure case when in fact it was a physically touching accident case, and I think most importantly, the judge's failure to properly rule on the 120-day rule and find that the carrier waived the right to deny compensability because it did not send a letter, or waived the right to deny compensability because it accepted compensability. All those require that your honors reverse this case and remand it with instructions to the judge consistent with what we've asked for in our briefs.
Thank you, counsel.
Thank you, Your Honor.
Thank you both for the argument. We'll allow you to reshuffle the courtroom here and bring up our second case.